Of all 27 amendments, the 13th is the one most people believe they already understand. It is the Abolition Amendment. It ended slavery. That is true, and it is among the most consequential things the Constitution has ever done. A single sentence that reached into the country and declared that one human being may no longer own another. But that same sentence carries an exception. Written into the very clause that abolishes slavery is a carve-out. And that carve-out is still in the Constitution today, unamended, still operative. It is the asterisk on abolition. So the question for this primer is really two questions folded into one. What did that one exception permit? And what does this amendment reach that none of the others do? Read the words themselves, slowly, because they are doing two jobs at once. Neither slavery nor involuntary servitude. That is the promise, and it is absolute, except as a punishment for crime whereof the party shall have been duly convicted. That is the exception, and it is narrow on its face, and enormous in its history. Ratified at the end of 1865, in the immediate aftermath of a war fought over exactly this, the 13th was meant to make abolition permanent and unrepealable. It succeeded. But the sentence that did it is not the clean, one-line prohibition that memory tends to make of it. It is a prohibition with a condition attached, and the condition is where a surprising amount of American legal history happened. This is Do It for the Case Law, Doctrine Deep Dive, Season 0, the amendments, one at a time, one sharpest gap each. Today, the 13th. Before we go further, there is a fact about this amendment that almost nobody knows, and it reframes everything. There was an earlier 13th Amendment, a different one, and Congress actually passed it. In the spring of 1861, with the country coming apart, Congress proposed an amendment designed to hold the Union together by guaranteeing slavery would never be touched. Its text would have barred any future amendment giving Congress the power to abolish or interfere with slavery within the states. Read that again. It was an amendment to make slavery permanently unamendable. A lock on the lock. It passed both houses by the required 2/3. The outgoing president signed it, which was not even necessary. And the incoming president, in his first inaugural address, said he had no objection to it being made express and irrevocable. A few states ratified it, then the war made it irrelevant, and it simply stopped. The 13th Amendment has two sections, and both of them matter. Section 1 is the abolition, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Section 2 is the power to make it real. Congress shall have power to enforce this article by appropriate legislation. Hold on to both halves of that first sentence because the whole episode lives in the tension between them. It abolishes slavery and involuntary servitude, completely, permanently. And in the same breath it says, except as a punishment for crime whereof the party shall have been duly convicted. Abolition, and an exception, in one clause. So the number 13 was, for a few years, attached to the opposite proposition, and the amendment we actually got came out of a war rather than a compromise. That matters for how it was ratified, because the circumstances were unlike anything before or since. Ratification required 3/4 of the states, and the question of which states counted was itself contested. Southern states were being readmitted, and ratifying the amendment was in practice a condition of readmission. Several of them ratified while under federal military occupation, by legislatures seated under federal supervision. You can hold two things about that at once. It is the only time the Constitution has been amended by a process that ran through occupied territory, and it abolished slavery. What it means is that this amendment does not rest on the ordinary story of national consensus. It rests on the outcome of a war, and the drafters knew it. Right, which is part of why they wrote the second section the way they did. Right, Section 2 is not boilerplate. The men who wrote this amendment had just watched the country try and fail to end slavery through ordinary politics. They were not going to leave enforcement to chance. So they gave Congress an affirmative power, appropriate legislation, to go and make the guarantee real. That enforcement power is the engine behind the statutes we are about to meet, and it is the reason the 13th is not merely a prohibition, but a source of legislative authority. Notice first, something about how that abolition works. Most of the Constitution's guarantees are restraints on government. They tell the state what it may not do to you. This one does something different. It abolishes a condition outright. It is self-executing in a way the others are not. The day it was ratified, slavery and involuntary servitude ceased to have any lawful existence anywhere in the country, whether or not any legislature lifted a finger. An involuntary servitude is broader than the word slavery standing alone. It reaches compelled labor and servile conditions generally, not only the specific institution of chattel slavery that had just been destroyed. Right, and here is the structural feature that sets this amendment apart from almost anything else in the Constitution. Look at the 14th Amendment, look at the 15th, the two other Reconstruction amendments, ratified in the same handful of years as this one. Each of them begins by naming its target, and the target is government. No state shall. Those amendments restrain what a state may do to you. They are built on what lawyers call state action. You need a government actor before the guarantee is even triggered. The 13th is different in kind. It does not say no state shall. It does not name a government at all. It says slavery and involuntary servitude shall not exist, full stop, anywhere, imposed by anyone. It reaches the private citizen directly. A private person who holds another in servitude violates the 13th Amendment with no state action required whatsoever. That is a reach the other Reconstruction amendments simply do not have, and it will matter enormously in a moment. Two features define how this amendment has actually lived in American law, and they pull in opposite directions. The first is the asterisk. Those words, except as a punishment for crime. We have to be plain about what that exception did, because it is not a footnote. When slavery was abolished, that clause left one door open. Forced labor remained constitutionally permissible for a person who had been, in the amendment's own words, duly convicted of a crime. And in the decades after emancipation, that door was used, deliberately and at scale. Southern states passed sweeping criminal laws, vagrancy statutes and the like, written broadly and enforced selectively against newly freed black citizens. A conviction, once obtained, could be turned into labor. Prisoners were leased out to private companies, mines, and plantations under convict leasing systems. And debt-based coerced labor, peonage, in which a person is compelled to keep working to pay off a debt, took hold across the region. The formal institution of slavery was gone. Systems of forced uncompensated labor persisted, now routed through the criminal law and shielded, in part, by the punishment clause. Congress eventually passed anti-peonage legislation, and the courts in time struck at debt servitude as a form of the very involuntary servitude the amendment forbids. But the point for this primer is textual, and it is uncomfortable. The exception was not theoretical, it was infrastructure. And note the mechanism precisely, because it is the whole grim point. The exception is not self-triggering, it requires a conviction. The party must have been, in the text's word, duly convicted. That single requirement is what made the criminal law the instrument. If forced labor is lawful only after a conviction, then the way to reach a supply of forced labor is to obtain convictions, which is a large part of what the flood of broadly written, selectively enforced criminal statutes was built to do. The punishment clause did not merely tolerate that arrangement, it supplied the constitutional shape of it. Now most treatments of this amendment stop there, gesture at modern prisons, and move on. We are not going to do that, because there is a settled body of federal appellate law on exactly what the punishment clause permits today, and you should know what it says. The exception has a source, and knowing where the words came from tells you something about how little thought went into them. They were not invented in 1865, they were copied. The Northwest Ordinance passed by the Confederation Congress decades earlier banned slavery in the Western Territories using almost exactly this formula. Neither slavery nor involuntary servitude, otherwise than in the punishment of crimes whereof the party shall have been duly convicted. That language was already familiar. Several state constitutions had picked it up. So when the drafters reached for a model, they reached for the one sitting on the shelf, and the exception came along with it. There is no record of an extended fight over that clause. No debate about what it would mean once a state could define crimes freely and then compel labor from whoever it convicted. The most consequential 13 words in the amendment appear to have arrived as boilerplate. Start with the foundational case Draper v. Ray, decided by the Ninth Circuit in 1963. A convicted prisoner argued he could not be compelled to work. The court held otherwise. A prisoner serving a lawful sentence has no federal right to refuse prison labor, and requiring him to work does not constitute the involuntary servitude the 13th Amendment prohibits. That holding became the template, and the circuits have followed it with striking consistency ever since. The Fifth Circuit pushed it furthest, and the details matter. In Ali v. Johnson, decided in 2001, the court held that an inmate cannot state a 13th Amendment claim merely because the prison requires him to work. And, critically, that it does not matter whether the sentencing judge actually imposed hard labor. You might think the exception, which speaks of punishment for crime, would only cover labor a court ordered as part of the punishment. The Fifth Circuit said no. Incarceration itself is enough. Earlier Fifth Circuit authority had also applied the exception to inmate labor performed on private property. Then there is compensation, and here the law is blunt. There is no constitutional entitlement to be paid for prison labor. Courts have repeatedly held that paying incarcerated workers below minimum wage or nothing at all does not violate the 13th Amendment when the work is part of a sentence of incarceration. The 10th Circuit restated exactly that as recently as this year. So the modern doctrine is not a narrow remnant. For a convicted prisoner, compulsory and uncompensated labor sits inside the exception, and the courts have said so over and over. Where the law does draw a line is on the two words people skip past: duly convicted. The Second Circuit took those words seriously in McGarry v. Polito, decided in 2012. A pretrial detainee, someone held in jail but not convicted of anything, was required to perform hard labor. The court held that the punishment exception simply does not apply to him because he had not been duly convicted. The 13th Amendment protects the person the state has not yet proven guilty. The court did preserve a narrow allowance for basic housekeeping, the ordinary chores of keeping a facility running, but hard labor compelled from an unconvicted detainee is outside the exception. That is the real shape of the modern doctrine, and it is worth stating cleanly. The line the courts enforce is not between humane and inhumane labor, and it is not between paid and unpaid. It is between convicted and not convicted. Cross that line, and the constitutional objection to compelled, uncompensated work largely disappears. That is what the exception does in operation today. Two honest caveats. First, a failed 13th Amendment claim does not mean a prisoner has no constitutional protection at all. The Eighth Circuit, among others, has been explicit that unusually dangerous or punitive work conditions may raise a separate question under the Eighth Amendment's Cruel and Unusual Punishments Clause. Different clause, different test. Second, some movement on this is happening outside the federal constitution entirely. A number of states have amended their own constitutions to strip out parallel punishment exception language, Colorado being among the first to do so. That is state constitutional change, not a shift in federal doctrine, and it does not alter a single one of the cases we just walked through. The second feature of this amendment runs the other way. It is the enforcement power, Section 2, and the question of how far Congress can reach when it legislates against slavery's aftermath. Here the story is carried by two cases, decades apart, reading the same amendment very differently. Start in 1883, with a decision known as the Civil Rights Cases. Congress had passed a statute guaranteeing all persons the full and equal enjoyment of inns, public transportation, and theaters, regardless of race. The Supreme Court struck it down. Part of its reasoning went to the 14th Amendment, and turned on exactly the state action point we just drew. The 14th restrained states. The discrimination here was by private businesses, so the 14th could not reach it. But the court also addressed the 13th, which has no state action limit, and it read the amendment's substance narrowly. The court accepted, in principle, that Congress could legislate against the badges and incidents of slavery, but it held that being turned away from an inn or refused a seat at a theater was not one of them. In the court's words, it would be, quote, running the slavery argument into the ground to make it apply to every act of discrimination which a person may see fit to make as to the guests he will entertain, or as to the people he will take into his coach or cab or car, or admit to his concert or theater, end quote. And the court concluded, flatly, quote, mere discriminations on account of race or color were not regarded as badges of slavery, end quote. One justice, John Marshall Harlan, dissented alone, and history has largely sided with him. But the majority controlled, and the practical result was that the 13th's private reach, though real, was drained of most of its substance. Public accommodations would go federally unprotected for another 80 years. That phrase, badges and incidents of slavery, is worth pausing on, because it is the hinge of the whole enforcement question. The idea is that slavery was never only the bare fact of being owned, it came wrapped in a set of disabilities and marks of inferiority, and Congress's power to enforce abolition might extend to stamping out those lingering marks, not just the institution itself. Everything then turns on who decides what counts as a badge and how generously they decide it. In 1883, the court kept that decision for itself and read it stingily. That, not the existence of the power, is what would change. Now move forward to 1968 and a case called Jones versus Alfred H. Mayer Company. A black family had been refused the purchase of a home for the stated reason that one of them was black. They sued under an old Reconstruction-era statute, Section 1982, a surviving piece of the Civil Rights Act of 1866, which guarantees all citizens the same right as white citizens to inherit, purchase, and hold property. Two questions. Did that statute reach a purely private refusal to sell, and did Congress have the constitutional power to enact it? The court answered yes to both. Here is the holding. In the court's own words, the statute, quote, bars all racial discrimination, private as well as public, in the sale or rental of property, and that the statute, thus construed, is a valid exercise of the power of Congress to enforce the 13th Amendment, end quote. Private as well as public. No state action needed, because the power flows from the 13th, not the 14th. And the court then described that enforcement power directly, quote, Congress has the power under the 13th Amendment rationally to determine what are the badges and the incidents of slavery, and the authority to translate that determination into effective legislation, end quote. It is worth registering how far that goes. The buyer and the seller were both private parties. No state law compelled the discrimination, and no state official carried it out. Under the 14th Amendment, that fact alone would have ended the case at the door. Under the 13th, it did not even slow it down. Sit with the contrast between those two decisions, because it is the whole doctrine in miniature. Both cases actually agree on the mechanism. Congress may legislate against the badges and incidents of slavery, and it may do so against private conduct because the 13th Amendment, unlike the 14th, needs no state actor. What changed between 1883 and 1968 was the deference. In the civil rights cases, the court decided for itself what counted as a badge of slavery and decided that racial discrimination in public accommodations did not. In Jones, the court handed that judgment to Congress, which rationally determines what the badges and incidents are, and a private refusal to sell a home to a black family fell squarely within them. Same amendment, same enforcement clause, opposite postures toward how far it reaches. The text did not change. What changed was the court's willingness to let Congress use it. So here is the thesis, and it is a genuinely two-sided one. The 13th Amendment is at once narrower than it sounds and broader than it looks. It is narrower than it sounds because of the asterisk. Neither slavery nor involuntary servitude reads as an absolute, and then the same sentence applies the exception, except as a punishment for crime. And that exception was not idle. It became the legal seam through which convict leasing and peonage survived emancipation, for decades, in the lives of real people. And as the modern cases show, it is not historical. It is load-bearing law right now, and the line it draws is conviction, not conditions. And it is broader than it looks because of the reach. Alone among the Reconstruction amendments, the 13th requires no state actor. It speaks to private conduct directly, and its enforcement power lets Congress reach the badges and incidents of slavery in private life, the power that, in Jones, reached a private home sale between two private parties. That is an unusually expansive tool, and yet it is invoked comparatively rarely. The 14th Amendment, with its equal protection and due process guarantees, does most of the day-to-day constitutional work in this area, while the 13th's private reach sits largely in reserve. There is one more place this amendment is doing live work right now, and it deserves saying because it cuts against the gloom. The second section, the enforcement power, is the constitutional foundation for the federal statutes against forced labor and human trafficking. Those prosecutions happen regularly, and they reach conduct that is purely private. An employer holding workers through threats, debt, or confiscated documents is not a state actor, and no other constitutional provision would reach him. This one does because it abolished a condition rather than restraining a government. So the amendment that failed to prevent a century of convict labor is simultaneously the amendment that lets the federal government prosecute forced labor wherever it finds it. Both of those are true. The same two sentences produce both results, and which one you get depends entirely on whether the person doing the compelling holds a conviction in their hand. That is the gap. A single amendment that cuts two ways at once. The clause everyone remembers, abolition, carries an exception most people have forgotten. And that exception did real, grievous work and still does legal work today. And the feature almost no one notices, that it binds private conduct with no state action at all, is one of the most powerful and least used grants in the whole Constitution. Narrower than its promise in one direction, broader than its reputation in the other. Both are true, and they are true in the same short amendment. And that duality is not a paradox to be tidied away, it is the amendment's actual character. The 13th did the single largest thing the Constitution has ever done, and in the same sentence, left a door ajar. It handed Congress a private conduct power broader than anything in the amendments around it, and then it was mostly left on the shelf while its neighbor, the 14th, did the visible work. To understand the 13th honestly is to hold both of those facts at once, without letting either one crowd the other out. That is the sample. A full Amendment 13 season on this show would take each of these threads in turn: the abolition itself, and what involuntary servitude has been held to mean, the punishment clause, the convict labor cases and the state constitutional amendments, now removing parallel language and the badges and incidents power, from the narrow reading of the civil rights cases to the broad one of Jones and wherever the law has traveled since. One doctrinal question per episode, each anchored in cases we verify, not cases we remember. A word on how this show works, and it matters more than usual on a subject like this one. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, and on a history this grave, the obligation to be careful only gets heavier. And everything here is built on real, named, verified sources. The text of the amendment itself, and the decisions of the courts, the civil rights cases, Jones versus Alfred H. Mayer Company, Draper versus Ray, Ali versus Johnson, and McGarry versus Polito, whose words were pulled from the court's own opinions before this script was written, with every citation in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.